I'd like to welcome Nadine Strossen, writer, law professor, activist, and public intellectual, to this series of talks about restrictions on sexual expression. Thank you, Nadine.
It's my
Your book-
pleasure. It's my pleasure to participate, Svetlana.
Fantastic. Your books have engaged the most difficult and divisive free speech issues: pornography and hate speech. Today, we'll talk about one of those issues, pornography, and your 1995 very influential Defending Pornography, Free Speech and the Fight for Women's Rights.
Free speech, sex, and the fight for women's rights.
There you go. Could you tell us about the feminist anti-censorship movement which provoked the writing of the book?
Yes, Svetlana. Starting in the early 1980s, a certain segment of the feminist movement in the United States began to move away from a general critique of sexist, debilitating, demeaning imagery of women in media generally, which was widely shared across the feminist movement, demeaning imagery in advertising, in other mainstream communications. But a certain segment began to focus more and more on pornography to the exclusion of other sexist imagery elsewhere in the media and in culture, and began, in fact, to insist that pornography is a major, if not the major cause, contributing factor to discrimination and violence against women, and therefore began to focus on advocating censorship of sexual imagery. And they used the very disparaging term pornography. I'm not sure how that comes across in Japanese, but in English, it is a very disparaging term that is inevitably used for whatever sexual expression the person using the term finds to be distasteful, as opposed to, say, erotica, which is positive expression. And I prefer to use the neutral term sexual imagery or sexual expression or sexually oriented expression. And that not only did this faction of feminism get a lot of media attention, they also got a lot of political and public support for this reason, Svetlana. Namely, there is another very influential segment of political actors in the United States. At that time, they were even more influential, the so-called religious right, people at the conservative end of the political and cultural spectrum, many of whom were associated with evangelical Christianity, fundamentalism, who had supported the election of then President Ronald Reagan. So they had a lot of political clout. They also objected to sexually explicit expression, but for completely different reasons from the reasons that were embraced by feminists, who, by the way, this segment of feminists was from the opposite end of the political spectrum, namely left or progressive. The cultural and religious and political conservatives thought that sexual expression was undermining what they called the traditional American family, or sometimes they refer to it as traditional family values. Namely, they saw sexual expression as advancing feminism, as advancing women's rights, as encouraging women to become more active in the political and economic sphere, and therefore reducing women's traditional roles as housewives and mothers. So the one thing that they agreed on is that sexual expression is dangerous and ought to be suppressed by the government.
Yeah, that it was a strange alliance between the left and the far right. And your book engages in the sort of the less usual suspects, the feminists. who were opposing pornography. We know that the religious right was opposing pornography, sexual expression, women's liberation for a long time. But here we had a new constituency of people that were our friends. So, and those advocates for censoring pornography contend, and they do that today as well as in the 90s, that women who perform for pornographic productions are inherently subject to abuse and exploitation, that pornography causes or at least contributes to violence and discrimination against women. How do you respond to that argument?
First of all, Svetlana, I hope this goes without saying, but I really want to underscore that throughout my entire adult lifetime, including when I wrote Defending Pornography to this day, I have been a staunch feminist. Nothing is more important to me than the full equal humanity and freedom and human rights for every person, regardless of factors such as gender or sex or sexual orientation. So I've been an enthusiastic supporter of women's rights and crusader against violence and discrimination against women. If I believed that pornography, so-called a sexual expression, really did promote violence or discrimination against women, I would be the first person to be advocating suppression of pornography. In fact, though, suppressing it does far more harm than good to women's rights. So let's get to the two alleged downsides of sexual expression from the perspective of women's safety and equality and dignity. Number one has to do with the women who are performing for sexually oriented productions. Of course, they can and have, in particular instances, been subject to abuse and exploitation, assault and harassment. Tragically, that fate is true for all women and all men and all people. In every profession, some of us have been subject to abuse and exploitation. It's one of the reasons why in the United States we have, fortunately, a growing body of law that is designed to protect against and to prevent and to remediate that kind of abuse. Everything such as OSHA, the Occupational Safety and Health Act. Unfortunately, when a profession is underground because it is illegal, it is impossible for those laws, workers' protection laws, to be enforced, and therefore it becomes much more dangerous for the people who are voluntarily choosing to make their living in that profession. And that's why sex workers of all kinds, including those who do perform for sexually explicit films and videos, have always opposed not only the criminalization of prostitution, but also have opposed censoring so-called pornography, even when it is advocated in the supposed name of feminism. And by the way, I am perfectly willing to assume that those who advocate censoring sexual expression are acting in good faith, that for some reason they believe that it will protect women from indignities and advance women's equality. But the evidence is consistently to the contrary. Now, precisely because there is no evidence that women or others who choose to make their living through posing or performing for sexually explicit work, there is no evidence that they are systematically exploited. And in fact, the so-called evidence that was recited by major proponents of censoring pornography, such as Catherine McKinnon and Andrea Dworkin, was completely anecdotal. And even their anecdotes turned out to break down upon examination. Their witness number one was a woman named, her stage name or film name was Linda Lovelace. She was a star of a 1970s classic pornographic film called Deep Throat. Her real name was Linda Marciano. And her evidence, her testimony, including before Congress and in a book she wrote, showed that she was subject to, sadly, a very common form of exploitation and abuse, namely by her own husband, right? Domestic violence is the major source of violence against women. And we're certainly not going to outlaw marriage because of the tragic instances of husbands and domestic partners who abuse their wives. But she had absolutely no, she explained that she was very happy and felt liberated and safe during the filming of Deep Throat. So from the lack of evidence, what those who advocate censoring sexual expression argue is, well, there is no such thing as actual consent to perform for these works. Women who believe that they are consenting are victims of false consciousness. They have been so brainwashed, in effect, by living in a discriminatory, sexist, misogynistic, patriarchal society that we have to protect them for their own good, just the way that we protect children. And in my book, I literally quote McKinnon and Dworkin as saying, as does their model law, it says so expressly, that women are to be treated along with children as inherently, legally incapable of consent to perform for sexual productions. And by the way, it even goes beyond that. They both argue, and again, I don't take my word for it, you can look at my book and the footnotes to their work, that women are inherently incapable of consenting to sex, period. You know, women who think we want to have sex with our husbands or other sexual partners are also victims of false consciousness. To me, this is the antithesis of women's equality, autonomy, and dignity. So let's get to the second claimed adverse impact of sexual expression, and that is that it allegedly is a significant causal factor in prompting men to commit acts of discrimination and violence against women, that it brainwashes men into seeing women as just sexual objects who are there to be abused. I have an entire chapter in the book that is a summary of every kind of potential evidence to back up this claim, from field data to correlational data to laboratory experiments to anecdotes, and every single category of evidence belies those claims. In fact, the country of Japan features several times in that chapter because Japan is a very prominent illustration of the fact that you cannot even show correlation between the existence of the availability of sexually explicit works and violence against women. And we all know correlation doesn't prove causation. So even if there were correlation, that would not show that the presence of the sexually explicit material was a significant cause of the rape and sexual violence against women. But there isn't even correlation. So it follows that, surely there cannot be a causative impact. Japan, at least when I did the research for the book, Japan was well known for the ready availability and consumption of sexually explicit work, including work that featured bondage and violence. Other countries where sexually explicit work was also and is also readily available include Germany and the Scandinavian countries. And those countries had a relatively low rates of violence against women. Conversely, some of the countries where violence and discrimination against women are the most rampant are countries where sexually explicit expression is completely outlawed, even in many cases subject to the death penalty. Good examples being the Islamic countries of Saudi Arabia and Iran. The purported benefits that would supposedly flow from censoring sexual expression, namely reducing violence against women who are the victims of men who look at sexual expression, reducing exploitation of women who choose to participate in the production of these works. When you examine the evidence, it turns out that neither of those is a justification. Again, it would do more harm than good by denying women who choose voluntarily to make their living that way, denying them their choices, denying them the safety, enhanced safety that comes from not being participants in an illegal business. And it also deflects attention from the actual causes of violence against women. May I add one other point about that, Svetlana? Because when you argue, as the pro-censorship feminists do, that looking at what they call pornography prompts men to commit rape, when you think about the logic, that reduces the responsibility and the culpability on the part of the men who are actually committing the acts of violence. And my book cites actual examples of men who committed brutal rapes against women, against girls, who actually are quoting McKinnon and Dworkin and other anti-pornography, pro-censorship feminists as supporting their arguments that, well, you should not hold me responsible. And Catherine McKinnon actually supported that argument. She said that those who produce these sexually explicit works are culpable. The men who actually commit the rapes are not culpable. To me, that is the opposite of advancing women's equality and safety.
I think it's very important that you point out that not only doesn't pornography do what anti-pornography feminists and the anti-pornography right is saying it's doing, but it's also harmful to broadly restrict sexual expression, including pornography. So can you talk more, and you already talked some, about what the negative consequences would be of such broad restriction, and who would be the most impacted if pornography was to be restricted?
So if you don't mind, we have to get into a little bit of terminology here. I've been using the neutral term sexual expression, or synonyms for that. The pro-censorship feminists use the term pornography not only because it has a very stigmatizing connotation, but they also, in their model laws, came up with a definition of pornography that is what they claim is the subset of sexual expression that should be illegal, because they wanted to distinguish it from obscenity, which is the legal term in American law and British law and in many other countries for the allegedly different subset of sexual expression that is not constitutionally protected. So let me start with the concept of illegal pornography for some feminists in the United States and Canada and other countries. And the basic concept is sexually explicit expression or sexually suggestive expression. And by expression, we, as usual, mean anything, whether words, imagery, and so forth, that is demeaning or degrading or dehumanizing to women. In other words, the idea is that somehow it undermines the full human status and dignity of women, as opposed to the traditional concept that was more appealing to the religious and cultural and political conservatives. They're more targeted at obscenity, which really in in a nutshell, is focused at sexual expression that is contrary to the morals or morality of the majority of society. The reason why I say that either of these concepts is an alleged subset of sexual expression is that the so-called definitions are inherently, irreducibly vague,
Absolutely.
broad, and subjective. Let's start with this concept of pornography, according to Catherine McKinnon and Andrea Dworkin and their supporters. Expression that is demeaning or degrading or dehumanizing. These are concepts that are so inherently value laden. No two human beings, not even any two feminists, can agree to which expression that would pertain. And so, predictably, when you give government or anybody else power to enforce these inherently elastic concepts, predictably, they are going to use it against expression that either they personally dislike, or if you're a politician, you're going to use it against expression that is unpopular in the eyes of the majority of your constituents, of powerful interest groups in the society. And so we see over and over and over again that these concepts are weaponized against groups who are relatively powerless, relatively marginalized, whose views are relatively unpopular. And guess what? Throughout American history, and in many communities to this day, those groups include women, they include LGBTQ individuals, they include advocates of contraception, advocates of abortion and reproductive freedom. And sure enough, if you look at the history of how obscenity laws have been enforced in the United States, they are enforced disproportionately against women and advocates of women's rights, advocates of reproductive freedom, and sexual and gender minorities and advocates of their rights. And by the way, when Canada adopted the McKinnon-Dworkin model anti-pornography law I believe it was in 1992, in a decision by the Canadian Supreme Court called Butler versus Le Guin, all of us who opposed that had sadly predicted that the first targets and the major targets would be feminist bookstores and LGBTQ bookstores. And sadly, our predictions came to fruition. The LGBTQ bookstores across Canada were raided and forced to shut down. Same thing happened with feminist bookstores. We also predicted that works by anti-pornography feminists themselves would be targeted because those works, of course, include graphic descriptions, and in some cases, visual reproductions of the very pornography that they were demonizing. And so sure enough, Andrea Dworkin's 2 of her books were confiscated by Canada Customs at the border. So I'm starting with some examples, Svetlana, but tragically, one could look at great works of literature, medical works, works of anthropology, books that were especially important to women's health, including the feminist health classic, Our Bodies, Ourselves, was repeatedly targeted and demonized. So the point is that nothing is safe, and especially unsafe are any voices on behalf of those causes and groups and individuals who have traditionally lacked political and cultural power.
Yeah, so since we mentioned obscenity and legal issue, let's look a little bit at the law around sexual expression. So in your view, what free speech principles should apply to regulating sexual expression and why?
And let me start by saying I will use First Amendment free speech law as illustrative of the general principles that I'm espousing, but I really want to stress that these principles have broad universal support through the Universal Declaration of Human Rights, the UDHR, which has been endorsed by every country in the world, and also the domestic law of many, many other countries. So these are universal principles that have been advocated throughout the ages and around the world. And in the First Amendment law has crystallized them very well into two fundamental principles. One explains what is not a sufficient justification for censorship, and the other one explains what is a sufficient justification for censorship. And these broad general principles, which in the United States apply to speech with about every subject, with every content, type of content or message, with the sole exception of some sexual expression. And I advocate that those same general principles should apply to sexual expression, as they do in many other countries, including Germany and the Scandinavian countries. And I'm not sure about Japanese law now, but certainly when I wrote my book, it was equally protective of sexual expression. So what government may never censor, let me just give you the shorthand name before I paraphrase the principle. The shorthand name for the anti-censorship principle is viewpoint neutrality or content neutrality. And what that means is government must remain neutral with respect to the content, the viewpoint, the message, the idea of the expression. Dislike of it, even fear or loathing of the content or viewpoint of the expression is never a sufficient justification for government censorship. Even if the vast majority of the community deeply hates the idea, what we have to do is respond with better ideas or ignore the one that we hate and so forth. And the second complementary general principle, which explains when government may censor, is often referred to as the emergency principle. When you get beyond the content or message of the speech and consider it in its overall context, if in particular facts and circumstances, that speech, regardless of its message, directly and imminently causes or threatens certain specific serious harm, then the speech can and should be censored. And the Supreme Court has recognized several subcategories of expression that satisfies the emergency principle. Some of them will sound familiar: intentional incitement of imminent violent or lawless conduct that's likely to happen, targeted harassment or bullying, a true threat that makes people fearful that they will be subject to attack, and so forth. So in the United States, we now have a very strong legal protection of free speech and speech with the most controversial content, including violent content, including disinformation and misinformation, including hate speech. All of this is completely protected from censorship solely because of dislike or general fear of its content. But all of it can be punished in particular factual circumstances if it satisfies the emergency principle. The sole exception to those general principles in American law is sexual expression. I do have to say, in fairness, the vast majority of sexual expression is constitutionally protected. However, the Supreme Court has carved out a relatively narrow subcategory that it labels obscenity, and it has come up with a three-part definition of obscenity. Once sexual expression satisfies that three-part definition, it is completely excluded from constitutional protection, even though there is not a shred of evidence that it causes any harm at all, let alone satisfies the emergency principle. It clearly is being discriminated against solely because of the disfavored content. In the United States, we are so protective of politically controversial speech, but we're so squeamish about sexual speech. It's kind of the opposite of many other Western democracies, or for that matter, democracies around the world, right? Where they tend to be somewhat less protective of hate speech and defamation that's critical of public officials, but more protective and many of them laugh at how frightened Americans are of the supposedly danger of exposure to sexual expression.
Why is that? Why do government officials and also community members, why have they sought through history and even today to censor sexual expression? What are their justification? Yeah, it is an outlier. It's a strange case among
Yeah,
other
and let me start by quoting the obscenity exception to First Amendment protection in the United States was first formally articulated by the Supreme Court in 1956. And the court started by explaining that most sexual expression is protected. And I remembered the exact words, Svetlana, because they were so compelling. The Supreme Court said, sex, a great and mysterious motive force for human behavior, has been of abiding interest to mankind throughout the ages. Well, yes, I mean, you go back to the cave paintings and sculptures, right, from the most ancient civilizations or pre-civilizations around the globe, and they include sexual depictions. So it would seem to be something that has been celebrated, expressing this basic animating force. And yet, I think the patterns that I described from the 1980s and 1990s in the United States still obtain, that no matter what it is that you are afraid of, you are willing to blame sex because it is such a powerful force as somehow causing that danger. So if you're a feminist who understandably is afraid of discrimination and violence against women, you look at sex as a causal factor. If you're a cultural or political or religious conservative who's afraid of the breakdown of the traditional moral fabric of society, you also look at sex and sexuality. At least I see that in the United States. And by the way, part of the reason why allowing government power to, or anybody power, but tech giants, whoever else has speech suppressive power, it's equally dangerous. And empowering them to suppress sexual expression is especially dangerous to the kind of expression that the Supreme Court has always said, and to the best of my knowledge, courts around the world agree, that in a democratic form of government, the most important expression is expression that we usually refer to as political speech, but it's broader than just politics, running for office. It means speech about public policy issues in democracies where we, the people, wield sovereignty and government officials are elected to be accountable to us. It's essential that we be able to debate public policy issues. And so many of them have to do with matters of sexuality. I mean, think about it: abortion, contraception, gay rights, gender identity issues, sexual harassment, sexual assault. All of these are sexual expressions. So on one hand, you have traditional treatment of sexual expression as somehow being a stepchild of the First Amendment, and yet they are all political expression about matters of public policy. There's an inherent tension there, which is why one of the reasons why I think why the Supreme Court has become less and less supportive of giving second-class treatment to sexual expression. And that's a trend that I think is going to have to continue.
Can you give us an outline of where the lines are drawn right now? Like we know that pornography is not the same as obscenity. Obscenity is legally defined, pornography is not. Where has the court drawn the lines as as we're speaking now around sexual expression?
Yeah, it's a really important question. And I do want to start with the fact that the vast majority of sexual expression is protected. For it not to be protected, the government has to prove that a definition of an unprotected category is satisfied. So there are two categories of sexual expression that the Supreme Court has carved out and said they are completely denied First Amendment protection. I already referred to one of them, which is obscenity. And basically, the Supreme Court created that exception in 1956. It has only revisited that exception one time, a long time ago, in 1973, when the Supreme Court reaffirmed that exception, came up with a three-part definition, but we have 9 justices on our Supreme Court. It was a 5-4 vote. So the court could not have been more split. And since then, many justices individually have strongly criticized the obscenity exception. So it's been less and less enforced. It remains there on the books. It never has been formally overturned, but it's actually being enforced less and less, in part for practical reasons. But the three-part definition is, number one, that the expression has to appeal to the prurient interest in sex, which the Supreme Court has defined as a sick and morbid interest in sex, as opposed to a normal and healthy interest in sex. You can understand how incredibly subjective these standards are. Number two, it has to be patently offensive. And both number one and number two, the prurient appeal and patently offensive, are defined in terms of contemporary community standards. And the work has to be taken as a whole. And then the third requirement is that, which we lawyers use a mnemonic device, the SLAPS test, the work has to lack serious literary, artistic, political, and scientific value. And that is defined according to national standards. So we can't dumb down to the intolerant standard of the most parochial, least tolerant community in the country. And all three of these criteria have to be satisfied. It's become harder and harder and harder for government to successfully prosecute it because of that SLAPS test, especially as we have the internet basically exposing people in even geographically what had been isolated and intolerant communities are being exposed to more and more sexual expression, and prosecutors recognize it's becoming virtually impossible to obtain convictions, except for child pornography. And that brings me to the second categorical exclusion of sexual expression under the First Amendment. But child pornography is completely distinguishable from obscenity in a very important way. Child pornography does satisfy both the viewpoint neutrality principle and the emergency principle. So it is not an exception to these general principles for this reason. The US Supreme Court has repeatedly defined constitutionally unprotected child pornography, not in terms of the content of the expression, but purely in terms of the direct harm that is caused to the actual children who actually perform and are exploited and abused in the production process. So even if something looks like child pornography, it's completely indistinguishable in terms of its content, but it turns out to be virtual child porn. In other words, it was made with computerized images or techniques. That is constitutionally protected. So I completely agree that, works that are the result of and perpetuate distribution of the exploitation of minors who are legally incapable of consenting to perform for these works, that should not be constitutionally protected. And so that is not an exception to the general First Amendment principles, the way obscenity is. Other than child pornography, which has this very specific and appropriately narrow definition, there are a couple other kinds of sexual expression that in particular contexts the Supreme Court has said are less protected, but they are becoming more and more anomalous. The major exception here is so-called indecent or patently offensive communications, specifically on broadcast media, over-the-air radio and television. Along with the obscenity exception, this goes back to very, very, very old cases. The Supreme Court has not recently revisited them. Some people will remember the famous 7 dirty words monologue that George Carlin gave, back in the 60s and 70s, 4-letter words that one supposedly cannot use. I'll use them now. I'll give a couple examples. Fuck being the most common example. Shit being another example. I mean, really dangerous words, right? That the Supreme Court has quoted in some of its most important cases. But if I were even to describe those Supreme Court cases in over-the-air broadcasts, they would be bleeped, and the stations would be subject to very heavy fines for allowing those words to be aired. This makes absolutely no sense at all when you could do exactly the same interview on exactly the same screen if it happened to be transmitted via the internet or via cable or satellite. It would be constitutionally protected. So that has become an increasingly anomalous exception. I don't know why the Supreme Court has refused to overturn it, but I think it's just a matter of time before that happens.
So where does pornography fit in here? It's clear that there's no legal definition of pornography, but could it be obscene? Because it does appeal to the prurient interest in sex. It could be patently offensive.
So when we talk about pornography, so the only legal concept of pornography in US law is this special child pornography. But there's other than that, the word pornography in general has no legal meaning in the United First Amendment law, and to the best of my knowledge, the law of other countries. But in particular, the definition that pro-censorship feminists attach to it as sexual expression that is demeaning or degrading or dehumanizing, that was actually embodied in a law that was passed in the city of Indianapolis back in 1984, immediately challenged in court by the American Booksellers Association and a coalition of mainstream publishing and library organizations, along with the ACLU and other free speech organizations, and was immediately struck down by a federal district court, the lowest level of federal courts. That was a ruling that was upheld on appeal by the U.S. Court of Appeals for the Seventh Circuit and reaffirmed by the United States Supreme Court in a procedure that is quite rare called summary affirmance, where the court deems the issue to be so simple and to have been so clearly, correctly resolved by the lower courts that the U.S. Supreme Court doesn't even receive briefs, written arguments, or hold oral arguments. In other words, this is simple and straightforward. Because when you think about it, Svetlana, remember that first major principle, which the Supreme Court actually has called the bedrock principle of freedom of speech, viewpoint neutrality. The feminist concept of illegal pornography squarely violates that cardinal viewpoint neutrality principle. It is not every depiction of sex that is illegal pornography. It is only those that allegedly convey a certain viewpoint about women, namely demeaning or degrading or dehumanizing toward women. So it's a classic violation of the most central principle of free speech. And certainly there is no satisfaction of the emergency principle, not one scintilla of evidence that basically any sexual expression would be subject to this incredibly broad and vague concept, and one could not show that any of it satisfied the emergency principle.
Yeah, I remember I have a very favorite two words from that decision, which is mental intermediation.
Yes.
It was that every kind of input of pornography, it goes through mental intermediation. It does not immediately cause violence.
According to the pro-censorship feminists, though, they really, I think their view of humanity is dehumanizing. Because they literally equated women to children. Again, you can see the exact quotes from McKinnon and Dworkin and others in my book, and they literally equate men to dogs. McKinnon said, showing pornography to a man is like saying, kill to an attack dog. And the ACLU Women's Rights Project filed a brief in this case, in which we argued. There was another group that made a similar argument, something called the Feminist Anti-Censorship Task Force, or FACT. And both of our briefs argued that not only did this law violate First Amendment free speech principles, but it also violated gender equality principles under the Equal Protection Clause. And because the courts ruled against the law on the First Amendment issue, they did not have to reach the Equal Protection Clause issue. But I remember one of the lines in the ACLU brief, and by the way, this is just a few years after Ruth Bader Ginsburg had famously founded that project. By then, she had gone on to a judicial appointment. She was no longer head of the project, but very, very much in her spirit, she strongly opposed these laws. Our brief said, any law that equates women with children and men with dogs is hardly a step forward for human rights.
Indeed. So, speaking of the Supreme Court, we have an interpretation of First Amendment law that's always developing, and we're now in the 21st century. We still have obscenity laws. How are obscenity laws developing? Is the obscenity exception contracting, expanding? Are there arguments accepted to expand child pornography, the child pornography expansion? What is the future what is the present and what is the trend?
Since 1973, when 4 out of the 9 justices rejected the obscenity exception, there have been continued attempts to get the court to repeal it altogether. But it simply, the Supreme Court has essentially complete control over which cases it hears and what issues it resolves. And for reasons that none of us will ever know, they continue to refuse to accept a case that would require them to re-examine and reaffirm the obscenity exception. That's disappointing. On the other hand, as an activist, I always see the glass half full. I'm an optimist. And there really is a very important glass half full, Svetlana, which is that there have been repeated attempts to get the court to expand the concept of constitutionally unprotected obscenity, and it has repeatedly refused to do that. For example, I already referred to a case that involved the F word. This came up during the Vietnam era when the phrase "fuck the draft," opposing the Vietnam era military draft, was fairly common. And a young man was actually criminally prosecuted and convicted for wearing a jacket that had that statement in it in a courthouse. And one of the arguments that was made by the government in seeking to uphold his conviction was that this should be treated as constitutionally unprotected, obscene speech. And the Supreme Court refused to do that. It said, at its essence, this has to do with the concept of appealing to the prurient interest, which is some kind of erotic interest. And they said the use of the F word in that context was not erotic. So I think it was a nod to the overlap between sexual expression and political expression. And when it's clearly dealing with matters of public policy, it's got to be protected. Another important example of the Supreme Court rejecting attempts to expand the obscenity exception. Quite a few people who, including liberals, who are very afraid of and concerned about violent expression, particularly when it's available to minors, have tried to harness the obscenity exception and apply it to violent expression. And most recently, the Supreme Court struck down a California law that was typical of laws that exist in many states that prohibited the sale to minors of violent video games. This was at a time when school shootings were associated with kids who had played violent games, and it was really believed that this is responsible for school shootings and for an epidemic of gun violence. And the Supreme Court, again, refused to allow that concept to expand the obscenity definition. With respect to child pornography, I already alluded to this, but it definitely bears repeating, which was, yes, the Supreme Court understandably said that expression that results from the exploitation and perpetuates distribution of images of the exploitation of an actual minor is unprotected. There was an effort to expand that concept to virtual child pornography, something that looked identical to pornography, but child pornography, but didn't involve the use of an actual minor. And the rationale was, the main rationale was, well, this will stimulate people who look at it to commit violence or make sexual advances toward children. And again, this underscored that the Supreme Court was enforcing the emergency principle and the viewpoint neutrality principle because it rejected that rationale. It said, no, the rationale for not protecting child pornography has nothing to do with its impact on the mind, the potential impact on the mind of the person who's looking at it. The only justification is the impact on the actual body of the person who's performing for it. So, and then let me mention one other example, the broadcast indecency concept, very outdated. It was controversial at the time it was adopted back, in the middle of the 20th century. It's become more controversial since then, but at least the Supreme Court has repeatedly rejected government attempts to also outlaw indecent or patently offensive expression in other newer media that it's considered. The government has tried to outlaw that expression on the telephone in the context of dial-up porn. The Supreme Court said completely constitutionally protected. The government made the same argument about cable TV, and made the same argument about internet, and the Supreme Court consistently and unanimously has, unfortunately, it has not yet overturned the broadcast indecency holdings, but it's refused to extend it to the other newer media. So, the existing restrictions on sexual expression are becoming more and more anomalous, not only in contrast to how we treat other controversial, unpopular kinds of topics or subjects, but it's also becoming an increasingly small subset of all the sexual expression that's available in all of the newer media.
But still, can you point at some recent current examples of attempts to suppress obscenity or pornography in the U.S., both legally and by the community?
Yes, there, one of the mantras for the American Civil Liberties Union, the ACLU, is eternal vigilance is the price of liberty, attributed to Thomas Jefferson. Who knows whether he actually said it, but it is true. Sexual expression continues to be demonized and targeted for suppression. From both the left and the right, from feminists and cultural conservatives alike. Most recent examples have focused on LGBTQ books and other expression in K through 12 curricula and in public libraries and school libraries. There's been an epidemic of book bannings that have been documented by organizations that track these trends, including the National Coalition Against Censorship, the American Library Association, and PEN America. And they show that in many, many states all over the country, both through individualized attacks on particular libraries or librarians, but also through legislative efforts, these books have been attacked, and often attacked under the rubric of pornography, because that's a stigmatizing term, and obscenity, because that's not only a stigmatizing term, but it actually means that the speech is illegal. And in a couple of jurisdictions, complaints have been brought to local prosecutors asking them to bring obscenity charges against the local librarian for daring to have included in the collection award-winning, critically acclaimed books that deal with sexual themes, but themes that are unpopular in a conservative community because they are fearful of LGBTQ sexuality. And a couple of states have considered, I'm not sure whether they've passed or not, but we're seriously on track to passing legislation that would expressly criminalize the certain expression about sexuality, even, and I'm thinking of what was a proposed law in Indiana. I'm sorry, I don't know whether it passed. I hope it didn't, but it was making too much progress last time I looked. That would have made it a crime to include in public libraries that kind of expression with that kind of sexual content, even if it had serious educational value. Now, the saving grace is if that law passed, it would immediately be challenged in court, just the way the other, Indiana, here we go again, the Indianapolis version of the feminist anti-pornography law was immediately challenged. So the First Amendment is a helpful backstop. But, not every librarian or school is aware of First Amendment principles, or may not want to go through the hassle and the stigmatization of being, can you imagine being accused of peddling obscenity or peddling pornography to kids, rather than come out successfully in a First Amendment claim? You can imagine the chilling impact. Well, let's just not acquire those controversial materials in the first place. So it leads to, and no doubt is intended to lead to, intimidation and self-censorship. Now, from the left, we continue to have excesses of, again, I support the goals here of those who are advocating suppression. I completely support the goals of equality and dignity and, safety for women. In that sense, I support the goals of the Me Too movement against sexual assault and sexual harassment. But, the pendulum has in too many cases swung too far to equate any expression with any sexual content or connotation in the presence of a woman who may find it insensitive or offensive, to somehow treat that as sexual abuse or sexual assault. And we've seen examples of this on campus, even of important discussions of sexual themes. Oh, one really poignant example for me as a longtime law professor is all the criminal law professors who feel they cannot teach about the incredibly important crime of rape because being exposed to that language and the sexual aspect as well as the violent aspect, they're getting students saying that they feel violated by that, they feel harmed by that, the words are violence. And to me, that is a perfect example of, I think, an inevitable confluence here that not only are these kinds of speech suppressive efforts violating free speech, they are undermining women's equality and impairing the effort to protect women's equality and safety, far from advancing those important causes.
Yeah, I think what's happening now is another book in itself, really coming from all sides, and enormous crisis in which teachers and librarians find themselves, being unsure of their jobs, unsure of whether they would be legally held responsible for books in the curriculum on library. It's a real crisis, and
even if you
there's
win. Even if you win legally, you can still have become a pariah in your community. And I think this is especially true in the smaller towns and more rural communities.
Yeah, absolutely. So when you wrote your book in 1995, aside from all this not being quite in place, the internet was not, it was in its diapers. It was just very, very new. And since then, it's become very pervasive. There's plenty of pornography on it. Does this technological development change your analysis at all? And the very concept of community, when we talk about obscenity, the very concept of community now is the 2 billion users of Facebook worldwide. What's happening with community? How has the spread of the internet affected your thinking on those issues?
So the First Amendment principles are very fact specific. I mean, their general principles and how they apply in particular circumstances is very fact specific. So I would apply exactly the same principles to the internet as to all other communications media. Indeed, that's exactly what the US Supreme Court held in the historic landmark case in which it first ruled on how the First Amendment applies online. And interestingly enough, and not surprisingly, the first case did involve sexually oriented expression, because in American society, that is always the most feared expression. So any new medium that comes along that makes it easier, cheaper, faster to disseminate expression, the first laws that are passed are to outlaw sexually oriented expression online. And sure enough, when Congress got wind of the internet, it passed with almost no dissenting votes a law called the Communications Decency Act, which would have made it a crime to disseminate any indecent or patently offensive expression. The ACLU immediately went to court to challenge it on behalf of the usual, basically the same coalition that we represented in the Indianapolis case, the mainstream publishers and library associations, but we also represented, I think this is very significant, major gay rights organizations, maybe major women's rights organizations, major human rights organizations, to make the point that the sexual expression that was demonized was especially important for these groups. Planned Parenthood was a major client in that case as well. And fortunately, in a case called Reno, as in Janet Reno was Bill Clinton's attorney general, the Clinton administration supported this law. Reno versus ACLU, the Supreme Court 9-0 struck down that law and said exactly the same top level speech protective First Amendment principles that apply to print media and other traditional media should apply online. The Clinton administration and everybody in Congress who voted for it was saying the opposite, that the internet should be treated the same way as the broadcast media that received the least speech protection. And one of the factors that the Supreme Court stressed in distinguishing the broadcast media from online was, and people still dispute whether this is actually a fair characterization of broadcast, but the Supreme Court hung its hat on speech suppression there and saying, well, it invades the home, the user is hit unawares, can't really choose what to see, whereas the internet, you can't have to affirmatively seek something out, and you can quickly look away if there's something that comes up that you did not do not want to continue seeing. So it's really designed for user agency. And if there are parents who want to protect their young children from seeing something online, it may be sexual, it may be violent, it may be political. Parents have end user blocking and filtering alternatives that can help them to implement their own value judgments and choices for their own young children without having to reduce the entire adult population in this country to seeing only what the most conservative parent deems fit for, the youngest child. I would say factually, the internet has also strengthened the anti-censorship argument in a number of ways, Svetlana. One of them is, you already alluded to, the proliferation of sexual expression online, the vast majority of which, to the best of my knowledge, is voluntary. People are voluntarily taking sex videos of themselves and putting them online,
They destroyed the porn industry.
I mean, McKinnon and Dworkin would say all of these people are victims of false consciousness. But I mean, it's interesting that if all these people are willing to do it completely for free, is it surprising that some people are saying we're voluntarily doing it for pay? And I think it's completely, it's laughable to say that they are all victims of exploitation that they're unbeknownst to themselves. Something
That's a
else.
great point.
And the another practical consequence is that I already alluded to. It would be very, very hard for a prosecutor to show that, with the proliferation of sexual imagery, including very graphic, explicit sexual acts online, people producing it, people performing in it, people consuming it. It's very hard to argue that this is patently offensive according to community standards.
This is incredibly interesting, and I'd love to go on for a long time, but we need to wrap up. And I want to ask you one final question. So given where we are today, what's your most optimistic prediction about possible changes to both the legal and social restrictions on sexual expression in the near future? What are you hoping for?
Well, again, as an activist, I'm an optimist, seeing the glass half full, and I think there's a tremendous basis for that optimism, because although the U.S. Supreme Court has refused to completely overturn the obscenity and broadcast indecency exceptions, it has not reaffirmed either one for many, many decades, and it has consistently refused invitations to expand those definitions. So the general trajectory of the Supreme Court's treatment of sexual expression, as well as other controversial expression, has been toward more and more respect for individual autonomy, individual freedom of choice, emphasizing other ways that people who choose not to see certain expression or hear certain expression can make their own decisions without a one-size-fits-all for the rest of us. In terms of society and culture, yeah, there are continuing attacks on all kinds of controversial, edgy expression, including sexual expression. But anything that comes from the government, I'm very confident is going to be shut down under the First Amendment. And I also think that there are very strong counter forces in our culture that are becoming more and more protective of sexual expression. In part, it's reflected by and has helped to drive the amazingly successful LGBTQ rights movement. I mean, when you think about it, both Barack Obama and Hillary Clinton, when they were running for president, opposed same-sex marriage. The trans movement, I think, was still deeply in the closet. And look how rapidly not only the courts, but society has come to embrace those causes. It's true, we've had, from my perspective, a real setback in terms of reproductive freedom through the Supreme Court decision. But when you look at public opinion, even among Republicans, even among conservatives, even among Catholics, even among evangelicals, the majority supports a woman's right to choose abortion in most circumstances. So the culture is becoming more and more supportive and discussing these issues very vigorously. So that goes hand in hand with vigorous support for freedom of expression about sex and through sexual imagery.
Thank you. Thank you for that positive vision. And thank you for your talk. This is really, really enriching.
Well, thank you so much, and to this very important project.